Hello everyone and good day to every one of you. Today we are going to cover on the remedies under the Contract Act. Okay, so today we are going to look at the remedies for breach of contract. First, let us understand what remedies mean. A remedy is a method used by the injured party to enforce their legal rights or recover a loss when the other party breaches a contract. Now, when a contract is breached, the remedy given by the court depends on the nature of the breach. Different cases may result in different remedies. Normally, the most common remedy of breach of contract is damages, which means monetary compensation. However, if money is not sufficient to solve the problem, the court may use its discretion and give equitable remedies instead. So there are five main remedies for breach of contract. Number one is damages. It's about financial compensation for loss suffered. Number two is a rescission, which is the canceling of the contract. And the third one is specific performance, ordering the party to perform the contract. Number four is injunction, ordering the party to stop doing something. And number five is quantum merit, the payment for work already done. Okay, so in short, remedies exist to protect the injured party when the contract is breached. The court will choose the most suitable remedy based on the situation. So let's discuss damages as a remedy for breach of contract. Damages are given to allow the innocent party to receive monetary compensation from the party who breached the contract. In simple words, damages mean money paid as compensation for the loss, damage, or injured suffered because a contract was not fulfilled. Damages are not a punishment. Their purpose is to put the innocent party in the positions they would have been if the contract had been properly performed. Under Section 76, a party who rightfully rescinds a contract is entitled to claim compensation for any loss suffered due to the non-fulfillment of the contract. So, damages are the most common remedy for breach of contract, where they provide financial compensation to the innocent party for losses suffered. So let's look at Section 74, compensation for loss or damage caused by breach of contract. So under Section 74(1), when a contract is broken, the innocent party is entitled to receive compensation from the party who breached the contract. However, this compensation is not unlimited. It only covers losses that, number one, naturally arise from the breach, or number two, were known by both parties at the time the contract was made to be likely to happen if the contract was breached. Now, under Section 74(2), compensation cannot be claimed for remote or indirect losses. This means losses that are too far-fetched or unexpected will not be compensated. Under Section 74(3), even if there is no formal contract, but the obligation resembles a contract and that obligation is not fulfilled, the injured party may still claim compensation as if a contract existed. And finally, when calculating damages, the court will consider whether the innocent party took reasonable steps to reduce their loss. This means the injured party must try to minimize the damage. So, Section 74 ensures fair compensation, not punishment. Only direct and foreseeable losses caused by the breach can be claimed. Next, we are going to learn about rescission as a remedy for breach of contract. Rescission allows the innocent party to cancel the contract when the other party has breached it. When a contract is rescinded, the contract is treated as if it never existed. The main purpose of rescission is to release both parties from their obligations and restore both parties as close as possible to their original position before the contract was made. This means any benefits already received must be returned, so neither party gains an unfair advantage. So, rescissions cancels the contract and restores both parties to their pre-contract position instead of giving monetary compensation. Next is about specific performance as a remedy for breach of contract. Specific performance is an order of the court that requires the party at fault to carry out the contract exactly according to its term. This remedy is not given automatically. It is granted at the discretion of the court. Under Section 21 of the Specific Relief Act, SRA 1950, the court may order specific performance when damages are not an adequate remedy. This usually applies when the subject matter of the contract is unique or special, and money alone is not enough to compensate the innocent party. So when is specific performance granted? Specific performance may be granted when monetary damages are not sufficient and when the court believes it is fair to force performance instead of paying compensation. So, specific performance forces the contract to be completed, and it is used only when damages are not enough to provide justice. Let's look at a case, a decided case, Zaibunsa binti Sheikh Ahmad versus Lo Kun Moy, which explain when specific performance may be granted. Now, in this case, A agreed to sell B certain pieces of land. The land was next to land already used by B for mining operation. Later, A refused to continue the contract. Because of this breach, B sued for specific performance, not damages. So what is the main issue of this case? Is monetary compensation sufficient, or should specific performance be granted? Well, the court held that the land was of particular importance to B. It was needed to support B's tin mining operations. Money alone or damages was not adequate compensation. Therefore, the court granted specific performance, ordering A to carry out the contract. So the legal principle here is that specific performance will be granted when damages are not an adequate remedy, especially where the subject matter is unique or it has special value to the plaintiff. Simple explanation based on this case is that because the land was essential for B's mining business, money could not replace it. So the court ordered the contract to be performed, not merely compensated. So specific performance is appropriate when the item involved is unique or irreplaceable, and damages cannot provide fair relief. Let's continue to discuss injunction as a remedy of breach of contract. Now, an injunction is a court order that restrains a party from doing something that is wrongful or against the contract. In simple words, an injunction stops a party from continuing or repeating a wrongful act that breaches the contract. This type of remedy is discretionary, which means the court will decide whether or not to grant it. An injunction will not be granted if damages are already an adequate remedy. So when is an injunction granted? An injunction may be granted to prevent a breach of contract or to stop a wrongful act from continuing, especially when money is not sufficient to fix the harm. So, injunction is used to stop wrongful conduct, and it is granted only when damages are not enough to provide justice. So, let's learn about the types of injunction in contract law. Again, injunction is a court order that stops a party from doing something that is against the contract. So, there are two types of injunction. The first one is temporary injunction. It is written under Section 51, subsection 1 of Specific Relief Act SRA 1950. It is usually granted when there is a serious question to be tried or when the balance of convenience favors one party. This injunction can be granted at any stage of a lawsuit, and it only lasts until a specific time or until the case is decided. Okay. The next one is on the perpetual injunction, Section 51, subsection 2, SRA 1950. A perpetual injunction is granted after a full trial. It permanently prohibits the defendant from continuing or repeating a wrongful act. Once granted, the defendant is permanently restrained. Okay. So, in Section 55, it discusses about negative agreement. An injunction can be granted to enforce negative agreement, which means a promise not to do something. We are going to look at this through two important decided cases, Lumley versus Wagner and Pertama Kabaret Nightclub Sendirian Berhad. Okay, so here, simple meaning when we say negative agreement, if a contract says you must not do X, the court may use an injunction to stop X from happening. Okay, so let's try to look at the cases here. Lumley versus Wagner. So let's look at the fact. What happened actually? Wagner was an opera singer who agreed to perform only at Lumley's theater for a period of time. She later refused to perform and wanted to sing for another theater instead. Lumley cannot force her to sing because court don't force personal services, but he asked the court to stop her from singing elsewhere. So the court held says that since he cannot force Wagner to sing, he can stop her from performing somewhere else. So this is negative injunction. So the principle is actually linked to Section 55 of SRA. Even if contract cannot be specifically enforced, the court can still grant an injunction to stop the breach. This is exactly what Section 55 allows, enforcing negative promises. Example, I will not work for others. Okay, so that is Lumley versus Wagner case. Let's look at another one. Pertama Kabaret Nightclub Sendirian Berhad versus Roman Tam. So the fact of the case, Roman Tam, a singer, agreed to perform only at Pertama Kabaret for a certain period of time. He later refused to perform and wanted to perform elsewhere. The club asked the court to force him to perform or to stop him from performing at other places. So the court held says that he cannot force him to perform. It's a personal service contract, and also refused to stop him from performing elsewhere where there is no injunction granted. Why is it different from Lumley versus Wagner just now? Well, the court found it would be unfair or too harsh to restrict his ability to earn a living. Injunction is discretionary, not automatic. So, principle that link to Section 55 SRA, although Section 55 allows injunction, the court will only grant it if it is fair and reasonable. And he will not grant it if it is causing hardship or injustice. So let's move on to the last one, which is the quantum merit as a remedy of breach of contract. Now, quantum merit means a claim for reasonable payment for a work done or services already provided, even though the contract is not fully completed due to a breach. In simple words, it allows a person to be paid for the work they have already done, not based on the contract price, but based on what the work is reasonably worth. This remedy is usually applied when a contract is terminated or breached, and one party has already partially performed the contract. So the purpose of quantum merit is to prevent unfair loss and unjust enrichment. Okay, so quantum merit ensures fairness by compensating a party for work already completed, even when a contract is breached before full performance. So when can quantum merit be claimed? So quantum merit allows a party to claim reasonable payment for work already done in certain situations. So there are two main types of cases where quantum merit can be claimed. The first one, when one party abandons or refuses to perform the contract. So we are going to look at one decided case, Planchet versus Colburn. In Planchet versus Colburn, the plaintiff was a writer who agreed to write a book for a fee of £100. The writer had already written part of the book, but the defendant stopped the publication, making it impossible to complete the contract. So the court held that the defendant had repudiated the contract. The plaintiff was entitled to quantum merit for the work already done. Even though the contract was incomplete, payment was allowed for partial performance. Number two, where work has been done and performed under a void contract. We are going to look at Craven Ellis versus Canon Limited. Now here, the plaintiff worked as a managing director under a contract. Later, it was discovered that the contract was void because the directors who appointed him were not legally qualified. Even though there was no valid contract, the plaintiff had already provided services. The court held that since services were rendered, the plaintiff could recover reasonable payment under quantum merit. Payment was allowed to prevent unjust enrichment. Okay? So, quantum merit can be claimed when one party refuses or abandons the contract, or when the work is done under a void contract. The purpose is to ensure fairness and prevent unjust benefit to one party. Thank you very much. That's the end of today's topic. I will see you again on another different topic. Thank you.